State of North Dakota versus Christy Marie Olson, 02-2026 CR 186. Again, Ms. Duffy appears in the Barnes County courtroom. Ms. Chisholm appears on behalf of the defendant by reliable electronic means. Ms. Olson appears by reliable electronic means from the Cass County Jail. And again, I am sitting in Stutsman County courtroom number 3, but the courtrooms are all open, and these are open and public proceedings. Ms. Olson, can you hear and see me okay?
Yeah, sometimes I've been noticing I've been having problems with connection, but right now it's good.
Present in court when your rights were read.
Yes, I was.
You understand all of your rights.
Yes, Your Honor, I do.
You received a copy of the charging document.
I haven't received anything from this jail.
I'm going to share my screen so you won't see my head. You'll still see the big courtroom that I'm appearing from. But I'm going to share that document on my screen so you'll see it in just a moment. Can you see that document now?
Yes, I do see it. I'm sorry, I was reading it real quick.
Is your name spelled correctly in the upper left-hand corner of that document?
Yes, it is, Your Honor.
Have the right to have me read this document to you, or I can summarize it to you.
You can summarize it. I already kind of ran through it myself.
It alleges that on or about August 15, 2026, in Barnes County, you committed 2 offenses. The first is a Class C felony, and the second is a Class A misdemeanor. In count 1, the state alleges that you possessed with the intent to manufacture or deliver a controlled substance, namely marijuana. Is charged that is a Class C felony. Class C felonies carry with it a maximum possible penalty of up to 5 years in prison, a fine of up to $10,000 or both. The state has not alleged any applicable minimum mandatory penalties for that offense other than a requirement that you submit DNA and fingerprints for inclusion in law enforcement's databases. Court fees associated with Class C felony total.
I don't mean to cut you off, and I know this is a courtroom, so I apologize. But on that one video, it said that you give a DNA sample if it harmed a kid or somebody.
Yeah, so I'm telling you that if you're convicted of a felony, the law requires...
Oh, okay, if I'm convicted. Okay, I'm sorry, I misunderstood you.
Yeah, so just stick with me, and I'll give you an opportunity to ask questions at the end. All right? So the state has alleged a minimum mandatory penalty involving DNA or requiring you to submit DNA and fingerprints for inclusion in law enforcement's databases. Court fees associated with the Class C felony total $525. There are some other penalties that we'll talk about at the end because they apply to both counts. In count 2, the state alleges on or about August 15, 2026 in Barnes County, you also committed the offense unlawful possession of a controlled substance, namely by possessing more than 6 grams of tetrahydrocannabinol oil. As charged, that is a Class A misdemeanor. Class A misdemeanors carry with it a maximum possible penalty of 30 days in jail, a fine of up to $3,000 or both. The state has not alleged any applicable minimum mandatory penalties except a requirement that you submit fingerprints for inclusion in law enforcement's databases. Court fees associated with only count 2 total $325. For both offenses, if your conduct caused any loss or financial harm to another person, the court can order restitution. For both offenses, if you're convicted, there might be significant adverse immigration consequences if you are not a United States citizen and you're convicted of either of these offenses. Likewise, there might be significant adverse collateral consequences that the law does not require the court to explain to you. To understand the nature of the 2 charges and penalties as I've read them.
Yes, Your Honor, I do.
All right, I'm going to stop my screen share. And again, because you're charged with a felony or your case involves a felony, I'm not going to take a plea of any kind today. That decision will happen depending on the outcome of a preliminary hearing, which in your case will be scheduled for September 10, 2026. You understand when you next need to be in court?
Yes, Your Honor, I do.
All right. So the only issue that's left for the court to decide today is the issue of bail. And so just like the last case, I'm going to hear from Ms. Duffy first, and then I'll hear from Ms. Chisholm, and then I'll give you an opportunity to be heard on the issue of bail. Ms. Duffy, go ahead.
In this case, Your Honor, the defendant has some criminal history, although it doesn't appear to be very significant. Most of her criminal history involves driving-related issues. She's got several driving under suspension convictions that go back many years. She did have a disorderly conduct that was a deferred dismissal. It appears she's from Minnesota, so I don't think she has any ties directly to Barnes County. I did run a III on her, and I looked through that. It looks like she has, I don't have access to Minnesota's court records since I'm not licensed there, but she does have a note in her III that she's got a failure to appear out of St. Cloud, Minnesota. She does, I would just comment, have what I consider a fairly common name. But same middle name and birth date, it appears that there's a failure to appear warrant out of St. Cloud. With that, I think that there could be a demonstration that she may not appear in the future. And I think that this is a case that would also be appropriate to set a cash bond. I'd ask the court to set bond at $750 cash, or in the alternative, a $5,000 surety, and additional requirements that she participate in the 24/7 drug patch, no leaving the state without the court's permission, and then just the standard conditions that she remains law-abiding and comes to court when she's supposed to.
Ms. Chisholm, your thoughts? Ms. Chisholm. Ms. Chisholm does not appear connected anymore. She was connected at the last hearing. I don't know if she, for some reason, thought she could disconnect, but she has. So, Ms. Olson, I do need to set bail, and I need to do so within 48 hours of your arrest. You were arrested yesterday, my understanding.
I was arrested on Saturday.
On Saturday. So
they didn't get my paperwork done.
Yeah, I'm going to set your bail, and that's going to happen right now. And again, if you...
So you need to stop
interrupting me. Stop now.
Because I thought it was...
Stop now. So I'm going to set your bail. I'm going to give you an opportunity to speak on the issue of bail. And again, I want you to understand that you have the absolute right to remain silent. If you choose to remain silent, that will not be held against you by me or by anyone else. If you choose to make a comment, ma'am, I want you to understand that anything you say can and will be used against you. These are recorded proceedings. And so I want you to understand that I would prefer that you make your comments, if you're going to choose to make a comment, have it reflect not the underlying facts of the offense or anything that might be construed as a factual admission, but rather just simply what you think bail should be and why. Ms. Olson, do you understand the court's warning?
Yes, I understand the court's warning.
All right. Is there anything you want to tell me before I set your bail?
As far as bail goes, I get SSI. I'm a single mom of 3 children. Like, I need to get home. And about the conditions, how does that work if I live out of state? And I'm from Minnesota, and that driving thing that I didn't know I had a warrant out for it. They just sent me a letter in the mail, and I got it after the court date. Minnesota doesn't do traffic violations like North Dakota. You don't get a date right at the time. They mail it out to you in the mail, and I didn't check my mail. But I will appear in court if I can get out on personal recognizances.
All right. Anything else, ma'am?
No, Your Honor, nothing else.
What's your plan for public defense services or the right to counsel?
I would try to get a court-appointed attorney for now.
So I've been notified
If I qualify.
Well, and I don't know if you qualify or not qualify, but you have the right to hire a lawyer. You have the right to apply for a public defender. And if you financially qualify for one, the court will appoint one for you. Or you can always choose to represent yourself. Again, Ms. Chisholm was connected at the beginning of the hearing. She ended up being disconnected, and I've been handed a note now that she is back online. So I'm going to ask Ms. Chisholm for her thoughts on bail, and then I'll make a decision. You're going to be required to apply for public defense counsel before you leave the jail under any circumstance. You understand, Ms. Olson?
Yes, Your Honor.
Ms. Chisholm, your thoughts on bail?
Thank you, Your Honor, and I apologize. I needed to leave the Zoom meeting shortly for an initial appearance in Richland County. However, I did catch that Ms. Olson does have no ability to post any money at this time, is asking for personal recognizance, and it sounds as though there may have been some failures to appear, but were based on some mailing issues, and so we would ask the court to consider her request as a PR bond at this time, Your Honor.
Okay. I need a little bit more information, Ms. Duffy. Are you saying that there was just a failure to appear, or there is an outstanding warrant right now?
So what it says is wanted, confirm that she's still outstanding. The agency is Sheriff's Office, St. Cloud, Minnesota, and then a bunch of numbers. Then it says Christy Marie Olson, appear, failure to appear case, and data warrant 7/21/2026. So just a few weeks ago, it looks like it would have been put in.
All right, thank you. Anything else, Ms. Olson? Again, I'm reminding you of the same warning I gave you earlier.
I'm sorry, this cut out. So if there was a question for me, I don't know what it was.
Ms. Olson, I'm giving you the last opportunity to speak. Is there anything else you want to tell me?
Just that thing in St. Cloud, I didn't know that I had a warrant. Like, as soon as I get out, I will call, I will take care of everything, because like I have children. I cannot have a warrant out for my arrest. That doesn't look good. I can't do that. I need to get that. I didn't know though.
Ms. Olson, do you understand that if you're in jail now and they know there's a warrant, they are going to serve the warrant and hold you until that's been disposed of? That's why I asked you, or that's why I asked the state, whether it was simply a failure to appear or if there is an outstanding pending warrant.
I think it was just because I didn't appear in court, because I didn't know that I didn't know I was supposed to.
I understand a warrant.
It was for a traffic violation.
Well, okay, but is there anything else you want to tell me?
No, Your Honor, I'm sorry.
Courts considered the constitutional provisions concerning bail, including Article 1, Section 11 of the North Dakota State Constitution. Courts considered Rule 46A, the release on recognizance or unsecured appearance bond presumption, unless the court has sufficient concerns over the defendant's likelihood of not appearing in court. Here, the court has sufficient evidence before it to rebut the presumption. I am concerned about the warrant outstanding. I understand there might have been an issue with receiving notice of the hearing. Notice would have been given before the warrant was issued, and if there is an outstanding warrant, the court has concerns that it will ultimately lose jurisdiction once Ms. Olson is transferred back to Minnesota, at least for a period of time, which poses the court some concern about the defendant's likelihood to appear. Bail will be set as follows: $750 cash or in the alternative, $5,000 corporate surety. Additional conditions: defendant shall remain law-abiding. Defendant shall participate in the 24/7 sobriety drug patch program. Defendant shall not leave the state of North Dakota or Minnesota without advance express permission of the court. Defendant shall maintain at least weekly contact with defense counsel, if any. Defendant shall notify the court of any change of address, employment, phone number, or email within 24 hours of any such change. Defendant shall not use alcohol or controlled substances unless prescribed. Defendant shall not possess a firearm or other dangerous weapon while on pretrial release. Defendant shall sign a promise to appear and waiver of extradition before release. Defendant shall complete and submit application for a public defender before release. Defendant shall personally appear for all scheduled court hearings and appearances. Next court date again, September 10, 2026 at 1 p.m. Central Time. Ms. Olson, I need to see you. So if you just put the iPad down, I can't see you. And you must lastly submit a DNA sample and fingerprints before release. Any questions about the court's bail order, ma'am? Ms. Olson, any questions?
No questions.
If you remain in custody for longer than 2 days, you have the right to request a bail review. Do you understand your right to request a bail review?
Yes, Your Honor, I sure do.
That we're adjourned. Have a good day.
Thank you so much.
Ma'am,
Yes.
that attitude needs to stop. I understand you might not be happy with my order, but what you're doing and that behavior, rolling your eyes and scoffing.
Oh, I'm sorry. I was rolling my eyes.
You need to stop talking right now. You've interrupted me throughout the hearing. You're giving me an attitude that is inappropriate. It's close to and bordering on contempt. Do you understand?
Yes, Your Honor, I do.
With that, we're adjourned.
And that's how this courtroom moment came to an end. But the real question is, was the judge right? Let me know what you think in the comments. If this case surprised you, hit that like button and subscribe for more unbelievable courtroom moments, shocking rulings, and intense judge reactions. We bring you the moments that make you say, wait, did that really just happen? So don't go anywhere. There's always another courtroom story coming next. Thanks for watching, and I'll see you in the next case.